All right, good morning, everybody. Hope everyone's having a good Tuesday morning. We're going to go ahead and get started. Uh, I do want to thank everybody for taking a little bit of time and joining us for this today. This is the Employee Drug Testing webinar, OSHA's view and the impact on workers' compensation benefits. Do have just a couple of housekeeping things to run through before we get started. This is going to be a slideshow today, so the slides will help you kind of follow along with the conversation as we go through the different areas. As we go, there's a chat function on the side. If you have any questions, you can submit whatever questions you have as we go. We'll do a little Q&A at the end. So send me the questions through the chat function, and I'll write them down, and we can address them all at the end. Then after the presentation today, it's also going to be recorded. So it'll be available anytime after this at societyinsurance.com. And then we also have a Society Insurance YouTube channel that this webinar and all of our past webinars are available for free anytime. So if somebody missed today and wants to catch it, or if you want to show some of your clients or staff or whatever, it's always going to be available. As everybody knows, things are a little bit strange right now. Everybody's working from home. So we are doing this webinar from 4 different locations in 2 different states. So we're going to hope there's no technical glitches. From our home offices, I know I've got a couple of dogs that have been very eager to chime in, and so they may make themselves known at some point, but hopefully they'll cooperate. Let's go ahead and get started. Just a little plug about Society Insurance. Society Insurance is a regional insurance carrier that's based in Fond du Lac, Wisconsin. We currently write business in 6 different states. We got Wisconsin, Illinois, Indiana, Iowa, Tennessee, and Minnesota. And so those are going to be the states we'll be focusing on today. We've been writing workers' compensation coverage since the beginning of 1915. We also have property, general liability, and commercial auto coverage, with our knowledge base mostly in protecting the hospitality industry. We provide specialty insurance for select business niches with a focus on the small details that make a bigger difference. Just a little bit about the presenters today. My name is Shelby Blundell. I've been a risk control rep with Society Insurance for just about 10 years, and I work mostly out of the Chicago area. So, and then we also have Pat O'Brien with us.
Yeah, I'm Pat O'Brien, and I'm a senior risk control representative. I've been with Society Insurance for 15 years now, working on 16, but I've been in the insurance industry for 24 years. I provide risk control services for our policyholders in Iowa, Minnesota, and the western half of Wisconsin.
My name is Kirsten Pankow, and I am a senior workers' compensation claims representative. I've been with Society for 15 years. I've been in the insurance industry in the claims area for 24 years, and I primarily handle Indiana and Illinois.
And good morning, everyone. My name is Brian Anderson, and I'm a risk control representative for Society Insurance. My territory encompasses southeast Wisconsin, and I've been in the insurance industry for over 10 years.
All right, look at that. The technology is working for us. And as with everything, we have to have a little disclaimer. So our legal department wants us to put that up, and we can move on. We've got 3 learning objectives today. So by the end of the webinar, you're going to kind of know what is considered permissible drug testing under OSHA's record keeping and reporting standards. Be able to identify best practices of a drug testing policy and necessary training. And then also you'll gain some understanding of what happens after an injury does occur. With this, we'll kind of break it down by your state, since each of them are a bit different, and we'll go through the states that we service. So let's get started. We are going to start out with a poll question, just to kind of see where everyone's at and their understanding. So if everybody could just enter yes or no, does OSHA prohibit post-incident drug testing programs. Give it just a few seconds here. I think 74% have voted. Overwhelmingly, it's looking like someone with the answer of no. And almost everybody has chimed in. It looks like 80% no and 20% saying yes. So what's your answer, Pat?
Well, actually, what we're going to do is we're going to make you listen to the rest of the webinar to kind of get a definite answer on that. But the 80% are probably just a little heads up, are probably in the right on that. So, really, in order to determine where OSHA currently stands on post-incident drug testing, we really need to kind of explore where they've been. So in May of 2016, May 12th, actually, to be exact, OSHA published a 273-page final rule, which amended a few things related to the reporting of workplace injuries and illnesses. So if you kind of think the electronic reporting that most businesses have to do, that was involved in some of those changes. Now, one of these items under 29 CFR, which is the Code of Federal Regulations 1904.35, which is employee involvement, was the addition of a provision prohibiting employers from retaliating against employees for reporting work-related injuries or illnesses. So this could include many things, such as verbal threats of retaliation, safety incentive programs were referenced, and of course we had post-incident drug testing. So now in the preamble to the final rule and that post-promulgation interpretive documents, try saying that 3 times fast, OSHA discussed how the final rule could apply to action taken under workplace safety incentive programs and post-incident drug testing policies. Now we're just going to focus on the post-incident piece. So OSHA's initial interpretation seemed to be that blanket post-injury drug testing policies deterred proper reporting, which meant that if you had a policy in place that automatically mandated drug testing after every incident, injury or illness, you were in violation of the law. Now, OSHA was not trying to ban drug testing. The rule just made automatic drug testing illegal because it had been shown to discourage employees from properly reporting injuries. Now, businesses could still, at their discretion, drug test an employee after an incident, but if you did, you had to have a very good reason to believe that the employee drug use was likely to have contributed to the incident, and the drug test could accurately identify impairment caused by said drug use. Now, this might be somewhat simple if the incident and resultant injury involved, let's say, a forklift accident, but wasn't so clear-cut if it was an incident resulting in a muscle sprain or a strain. Now, if we fast forward to October 11th, 2018, OSHA released a memo with the purpose of clarifying their position on post-incident drug testing, as well as incentive programs. But again, we're just talking the post-incident drug testing piece. It basically stated that you do not prohibit workplace post-incident, or I should say they do not prohibit workplace post-incident drug testing. In fact, it is quite the opposite. They believe that many employers who conduct post-incident drug testing do so to promote workplace safety and health. So evidence that an employer consistently enforces work rules regardless of an injury or an illness being reported would show that the employer is serious about safety and not just trying to reduce insurance premiums. Now, the key word here being consistently. So if we jump to examples of permissible drug testing, in most instances, workplace drug testing is permissible under the standard, including we have random drug testing unrelated to the reporting of work-related injury or illness, drug testing under a state workers' compensation law, drug testing under other federal laws, such as your Department of Transportation rules, drug testing to evaluate the root cause of workplace incident that harmed or could have harmed employees. So if the employer chooses to use drug testing to investigate the incident, the employer should test all the employees whose conduct could have contributed to the incident, not just the employees who reported those injuries. So if you're still kind of wondering where your post-incident drug testing policy stands, well, first, you no longer need to analyze whether there was a reasonable possibility that drugs or alcohol could have contributed to an accident. Instead, broad post-accident drug and alcohol testing is permitted, subject to any other applicable laws that may have different requirements. All prior OSHA interpretive documents can be construed as inconsistent with the interpretive position, so that October 2018 memo supersedes all of them. That memorandum also instructs agency officials to consult with OSHA's Directorate of Enforcement programs before issuing any citations relating to safety incentive or drug testing policies. And that falls under 1904.35 B14, which states, you must not discharge or in any manner discriminate against any employee for reporting a work-related injury. So really, from an employer standpoint, the employer takeaways is the key takeaway from the memorandum is that most drug testing programs are permissible, including drug testing that you could conduct to evaluate that root cause of a workplace incident that harmed or could have harmed employees. Again, as long as the employer tests all workers who could have contributed to the incident, not just that employee or employees who reported injuries. Finally, you might be asking, what about workers' compensation and how does that apply when states that you are required to drug test? Now, that is a great question, and I appreciate you for asking. OSHA's response is that, and I'm going to quote OSHA here, if an employer conducts drug testing to comply with the requirements of a state or federal law or regulation, the employer's motive would not be retaliatory, and the final rule would not prohibit such testing. So with that, I am going to turn it back to Shelby, and I think he's got another poll question.
All right, and with that, we've had our first technology fail. My poll question has disappeared, so I can't open it and launch it for everyone to answer. So I'm just going to say when are insurance carriers liable for post-accident drug testing? And I will turn it over to Kirsten to offer the answer.
Okay, thank you. So, as he said, the poll question is, when are insurance carriers liable for post-accident drug tests? Let's go to the next slide. And what we'll do is we'll go through the 6 states that society currently writes business in. So let's look at the cost of a drug test. Workers' compensation insurance does not pay for post-accident drug tests. Though company clinics do send bills directly to carriers, they will be returned to either the clinic or the employer, advising that the insurance company is not responsible for payment. Workers' compensation pays for medical treatment, and post-accident testing is not considered medical treatment. Let's first look at Wisconsin. As of March 2nd, 2016, if an employee violates an employer's policy regarding employee alcohol or drug use, and that violation causes a work injury, the employee loses the right to all workers' compensation benefits except for medical expenses, which was under the statute 10258. Previously, the law provided for a potential 15% reduction in benefits if an injury was the result of intoxication or the use of controlled substances. Now, an employer can revoke all indemnity benefits, though the employee is still entitled to medical, where the employee violates an employer's drug or alcohol policy, and that violation directly caused the workplace injury. Employers should strongly consider drug testing post-accident if they do not already have a policy in place. In the event an employee violates a written drug or alcohol policy, is injured, and the violation directly caused the employee's injury per a medical opinion, the employer will not be responsible for any indemnity benefits. Moving on to Minnesota. Minnesota is one of 12 states which have mandatory workplace drug testing laws. Workers' compensation insurance companies may deny benefits because employees test positive for drugs. If the employee challenges the denial, the insurance company has the burden of showing that the alcohol or drug use led to the injury. Specifically, the insurance company must show, first, that an employee was intoxicated by drugs or alcohol at the time of the injury, and second, that the intoxication was the direct cause of the injury, not just a factor, among others, that led to the injury. The same standard of proximate causation exists for drug use, just as with alcohol. The courts have held that establishing intoxication of the employee is a question of fact. They have held that this fact can be established by any competent evidence, whether direct or circumstantial. The blood alcohol content of the employee is one relevant factor that can be considered, but is not determinative, especially if it is the only evidence offered. Other relevant factors may include observation of witnesses, the employee's actions prior to the injury, and the employee's tolerance for alcohol. They often recommend having a toxicologist review the test results, as they can extrapolate back to the time of injury, if that is known, and provide an opinion regarding whether the employee was in fact intoxicated to the point of impairment, based upon the level of alcohol or drug use at the time. Courts have consistently held that intoxication is a bar to compensation only when it is the proximate cause of the injury, not merely a contributory cause. The courts have held that this proximate standard test is a high legal standard and it is difficult to prove. Moving on to Iowa. In Iowa, an employer may require an employee to undergo a post-accident drug or alcohol test if the employee is injured and requires medical treatment or if there is property damage over $1,000. If an injured worker tests positive for drugs or alcohol after suffering a work injury, the claim may be denied by the intoxication defense. The law presumes that the drug or alcohol in the injured worker system was the cause of the work injury. However, the injured worker is entitled to fight this presumption. If the injured worker can prove that the test was not in fact positive, or that the substance found in his system was not the cause of the work injury, then the injured worker is entitled to Iowa workers' compensation benefits. Tennessee. Tennessee's workers' compensation law has long included a provision stating that an injured employee that has a blood alcohol level equal to or greater than 0.08 for non-safety positions or 0.04 for safety-sensitive positions, then it is presumed that the alcohol was the cause of the injury. The same holds true for a positive drug test. Workers could rebut the presumption if they could prove to a workers' compensation judge that the drug or alcohol was not the cause of the injury by a, quote, clear and convincing evidence. The same legal standard also applies in cases where an injured worker refuses to submit to a test following an injury. Please note that we may be able to deny benefits if the employer is not enrolled in the DFWPP, which stands for the Drug-Free Workplace Policy. The insurer has the ability to withhold indemnity benefits if the employer has a drug policy that isn't followed, but it is not an automatic denial. The only way to automatically deny a claim is if the insured enrolls in the DFWPP, which is hosted by the Bureau in Tennessee. The employer must re-enroll each year and follow set standards according to the Bureau. If the employer enrolls in this and submits proof of enrollment, they are entitled to getting a reduction in their policy premium. If the insured enrolls in the DFWPP yearly, then an insurer is able to automatically deny claims for an employee test positive. Indiana does not have a workers' compensation provision addressing drug testing, either in the Indiana Code or the administrative rules. This will help protect the company and maintain worker safety while protecting an employee's rights to be free of retaliation for filing a workers' compensation injury claim. According to the Guide to Indiana Workers' Compensation, you may still be entitled to benefits after a positive drug test. The rule of thumb is that if the employee's accident was caused by intoxication, then he or she would not be entitled to workers' compensation benefits. Otherwise, the worker would still be eligible for benefits. The employer has the burden of proving that the intoxication was the proximate cause of the work accident. Finally, Illinois. In Illinois, an employer can deny all medical, temporary total disability, and permanent partial disability benefits based on a positive drug test. The case could be denied if, first, the injured employee's blood alcohol level is 0.08 or higher. Second, there is any evidence of impairment due to the unlawful or unauthorized use of cannabis, a controlled substance, or intoxicating compound. Or 3, if the employee refuses to take a test. Drug intoxication creates a rebuttable presumption that the employee was intoxicated and that the intoxication was the proximate cause of the employee's injury. Drug intoxication is not a per se bar to workers' compensation benefits being awarded by the Commission. An employee may overcome the rebuttable presumption by the preponderance of the admissible evidence that the intoxication was not the sole proximate cause or proximate cause of the accidental injuries. In order for any testing to determine whether the employee was intoxicated at the time of the injury to be admissible, the testing must be performed by an accredited or certified testing laboratory. In 2012, the Illinois Workers' Compensation Commission adopted rules on sample collection and testing for alcohol and drugs necessary to implement these changes to Section 11 of the Illinois Workers' Compensation Act. In summary, cases in this area, as in most arising out of cases, are very fact-specific. The facts are often subject to more than one interpretation. It is the Commission's duty to resolve disputed factual questions, draw reasonable inferences and conclusions, and judge the credibility of witnesses. The Commission's findings will not be reversed on appeal unless they are against the manifest weight of the evidence. It is highly advisable to have the drug and alcohol policy outlined in the employee's handbook with a signed confirmation from the injured worker.
Okay, we've got another poll question, and this one is kind of our curiosity of where you guys are. So do you have a drug testing policy in your company? Do you not have one? Or do you just not even know? Got about 60% in. It's leaning towards no. Give it a few more seconds here. Okay, we got about 85% of the vote in. It looks like 51% have no policy, 39% yes, they do have a policy, about 10% don't know. So that's interesting. But, yeah, turn it over to Brian.
Perfect. Just going to go through drug testing policies. Some of the best practices when you do have a drug testing policy is that it is a formal written policy. Employees should sign the policy, which acknowledges that they received a copy and understand the consequences. Anytime the policy is updated, each employee should sign the new policy as well. The drug testing policy should comply with all state and federal laws, similar to what Kirsten went through. And the drug testing policy and consequences must be consistently enforced amongst all employees. An employer cannot be more lenient on a long-term employee versus a short-term, someone that's only been there a year or two. And this could potentially lead to discrimination lawsuit if you do that. So what kind of things are needed for a drug testing program from a training standpoint? Employers should train management and supervisors on the policy and how to enforce it. If reasonable suspicion drug testing is part of your drug testing policy, which we do see quite frequently, management and supervisors should be formally trained on reasonable suspicion. Employers must drug test immediately when there is a reasonable suspicion. The human body metabolizes alcohol and drugs, so if you wait several hours or days, the employee may test negative. Additionally, by waiting, you are placing your other employees' safety at risk, as the affected employee could do something unsafe, injuring others. When talking with the employee, do not accept excuses. Common excuses that we see are the person complains of lack of sleep, they forgot to take a medication, they started taking a new medication, or they have distractions in their personal life. Testing should occur no matter the excuse. While the excuses could be true, reasonable suspicion occurred, which should then include a drug test. Once again, consistency using the policy is very important. And then the Employee Assistance Program. The Employee Assistance Program is a voluntary work-based program that offers free and confidential assessments, short-term counseling, referrals, and follow-up services to employees who have personal and/or work-related problems. These EAPs requirements vary state by state, so we're not going to go into the specifics.
Okay, now we've got a few minutes that we can do some questions and answers if anybody has any. Like I mentioned, the chat function on the side is where you can type in what your question is. We're not going to answer a lot of scenarios or what ifs. If you've got specific questions about, that might apply specifically to your operation or whatever, direct that to your agent. They will be able to give you better answers on that kind of stuff when you can kind of discuss the details of it and whatnot. But see if there's any questions. Got one question here. Somebody just asking, where can I find more information? And I'm going to guess that that's more like basic information about the OSHA drug testing policies or whatever. Pat, do you want to take that?
Yeah, sure. And actually, I'm going to kind of punt on this one a little bit, only to say that I would recommend looking at OSHA's website, OSHA.gov. It's actually one of the better government websites out there. You can search OSHA record keeping, kind of key on that 1904.35 employee involvement, and it will go through there. You can jump to links that will take you to some of those memorandums we discussed. If you want to go through the 273-page final rule, feel free, but I would kind of focus on that October 11th, 2018, and I'll kind of give you a synopsis of where they stand as far as post-incident drug testing.
Okay. And then asking who should be doing a review of a post-accident drug policy. Brian, you want to take that?
Sure. We always recommend having your legal counsel take a look at those policies for you to make sure everything falls in line properly.
Okay, thank you. Those are the only two questions I had come in. So with that, then I do want to thank everybody for joining us today. I hope it's been some helpful, have some helpful information, some of the best practices and stuff like that. If you remember, if you want to go to societyinsurance.com, this will be recorded and available there on the YouTube channel, and then all of the other webinars that we've done. We tend to do several a year and on a variety of different topics. So thank you for taking a few minutes, and hope it was good. Have a good day. We'll see you all later. Thank you very much.